on to the general election. And the person who wins on that day, on the general election, will serve a 6-year term. So today we have, in order of how they will be, the answer to the questions is Bob Cooney, Paul Jarboe, and Haider Kazim. So there will be a 3-minute opening remarks. You can talk about yourself and why you're running, different things, whatever you guys want to do. And then it'll be 2-minute questions from then on, and we'll be ending around 7 o'clock. Perfect. And if you guys have any questions, this is mainly run by you guys for questioning, or questions for them. Laura is walking around. Thank you. Walking around, she's having a red thing over there. Raise your hand, Laura. If you have a question, get a note card from her and a pen, write your name, or write your question, and if you do want to say yours out loud, unless you want us to, write your name on it if you would like to say it. So, yeah, and with your questions, according to the Michigan Code of Judicial Conduct, Canon 7, please do not ask them to promise anything and keep it politically unbiased. So, thank you and enjoy the forum.
Keeping it politically unbiased.
Mr. Cooney, you can go ahead and look it up here.
Good evening, I'm Bob Cooney. I'm the Grand Traverse County prosecutor.
Speak to the microphone.
Oh. Again, good evening. So, can I start?
Yes.
Start over, Bob.
There.
Good evening.
Speak up.
Good evening.
Nice and close.
Can everybody hear me?
Because judges have microphones. You're going to have to maybe not. I don't know about that.
Hello.
Hello.
There we go. Yeah, good evening. I'm Bob Cooney. I'm the Grand Traverse County prosecuting attorney. I've been elected in 2012 to 2016. Been in the prosecutor's office of Grand Traverse County now for 25 years. I tried just about every type of case you can imagine from my 6 years primarily assigned to the district court for which I'm running, from assault and battery to domestic violence to murder, rape, and armed robbery. I have argued appellate cases before the District Court of Appeals of the Michigan Supreme Court. I manage an office with a budget of approximately $1.8 million and stand for 15 persons. I set all policy and procedures in our office. I've been endorsed by 2 retired district court judges, former Judge Michael Haider and former Judge James Foreman. I would be honored to serve as your next 86th district court judge. I have a long history of public service and going back to serving with the Michigan Court of Appeals, pre-hearing attorney, and prior to that 5 years working for the United States Army as a civilian engineer. So again, I would be glad to have your support in my campaign for 86th district court judge.
Good evening. I'm just going to speak up because I'm not sure that's working that well. My name is Paul Jarboe. I'm an attorney here in Traverse City. I'm 60 years old. I've been a practicing lawyer for over 35 years. I have served as a prosecuting attorney in Flint. I've served as a partner for 2 major law firms up here in northern Michigan. And for the past 14 years, I've had my own practice out with one partner in Traverse City. I'm married to my wife, Suzanne, who's here.
Hello.
And the most important thing going on in our life is that she just got it all clear on a cancer diagnosis. So we went from you have stage 4 lung cancer to everything's clear. So God's grace is good. Amen. Amen. But I want to talk to you about why I'm running for judge. And this is actually the second time I've done this. I ran 14 years ago with John Forsman, who was our elected county prosecutor, was elected. And I ran then and I run now because I'm a practicing trial lawyer. I work in the trial court. I'm probably the only candidate that actually works not only in Grand Traverse County, but Antrim County and in Leland County. And I've handled cases not only as prosecuting attorney downstate, but also as a civil lawyer, as a criminal defense lawyer. I've been appointed by the circuit court to serve as an arbitrator and as a mediator in domestic relations cases. I've tried family law cases. I've handled just about every type of case that comes before our trial court, which are district court and circuit court here in Michigan. I've also handled cases and argued cases before the Michigan Court of Appeals, and I've filed cases with the Michigan Supreme Court. I'm very well experienced. And that's what I believe I bring to this position, is a variety of experience in not only criminal law, prosecution and defense, but also civil law. I also have been very active in our community. I was one of the founding members of the Traverse City Christian School Association. I was the president of Good News Media, which runs WLJN Christian Radio in town. I was appointed to the Garfield Township Planning Commission, and most recently was asked to serve on the board of trustees for the Old Town Playhouse. I'm endorsed by a number of lawyers and judges, including John Forsman, who was our former county prosecutor and former 86th District Court judge, and also sitting Judge John Meade, who's our District Court judge down in Denison County. So I'm running because of experience. I believe I have the right temperament to bring to the District Court bench. Thanks.
Well, good evening. I'm going to use my voice too rather than the microphone. My name is Haider Kazim, and I am also running for the 86th District Court Judge position. I've been a municipal attorney for 15 years. I started my legal career in Northern Michigan with a firm in Bel Air. I worked there for 4 years before I moved to my current firm in Traverse City. In those 15 years, I've had the privilege to represent counties, including Grand Traverse, Antrim, and Leelanau counties, townships, cities, road commissions, sheriff's departments, and fire departments throughout Northern Michigan and the Upper Peninsula. And in that position, I've had the opportunity to practice in a wide area of law. As you can well imagine, if you're representing a municipality, you are dealing with a whole host of issues that involve business law, contract, property, zoning, ordinance enforcement, employment, personnel, etc. The best thing that you want in a judge is that breadth of experience. And I believe I'm the only candidate in this race that has that breadth of experience to hit the ground running from the first day on the job. I've had the privilege of practicing in courts throughout the state. I practiced in state courts and in federal courts. And through that experience, I've developed insights into what qualities of a good judge are. A good judge must treat everyone fairly and equally, regardless of who they are, that appears before them. He has to be prepared, and he has to treat every issue with the equal degree of seriousness and preparation and deliberation, regardless of the seriousness or the dollar amount involved. And that is what I'm promising to bring to this position if I'm elected. I have been in private practice all 15 years. So I have not been a public servant in the quintessential definition of the term. But I'll tell you this, when you are a municipal lawyer, you are representing the communities, the people who live in those communities. And that has been my privilege to advocate for their interests, for their goals, and on their behalf as a municipal attorney. I want to take my experience in private sector, representing those communities, and I want to bring that into public service as a judge to continue to serve the people in my community to whom I owe a great deal of debt and gratitude. And for that reason, I'm asking for your support on August 7th. Thank you.
Okay, thank you, gentlemen. Has everyone who would like to put in a question done so? If not, there's still time if you'd like to. Okay, and throughout this entire forum, you're welcome to put more in, just like down the road. So if I can have the. Okay, we are going to start with the question. Gentlemen, you will have 2 minutes to answer each question. All of the questions that we'll be asking you are from the audience. I don't know how to word this one. What is your civil infractions? I don't know. Civil infractions. Deny discovery. I believe this is wrong. What
say you?
What say you? Wow.
Am I supposed to?
Please go ahead.
Yes. What I would say about that is that I have been a proponent of discovery in misdemeanor cases for a long time. Because misdemeanor cases, which are the cases we're handling in district court, are very important to the litigants involved. And you may not know this, but of course in felony cases, we turn our police reports over to the defense counsel, and they have reciprocal discovery. They have to tell us what their witnesses are. We show up in a misdemeanor case, which is not a civil infraction, but misdemeanor cases, and we don't even know who the defense is calling as a witness. I think that's wrong. I think the prosecution should have an equal opportunity to try the case with all of the evidence and having an opportunity to prepare the case properly. I don't know about civil infractions. I think the reason for limiting discovery in misdemeanor cases probably has something to do with bogging down the courts with too many issues regarding discovery, as sometimes happens in our civil cases. But I'm in favor of both parties going into a case with full knowledge of what the other side has to present.
Okay, thank you.
Same question.
Yes.
Okay. Can I ask you, would the person who wrote the question mind raising their hand? Okay. What was it that you were looking for?
All right, there's no discovery allowed in civil infractions.
Yeah, now civil infraction, we would define as like speeding tickets.
Exactly.
Those
Speeding
things.
tickets, code enforcement, are civil infractions,
Okay.
many of them, and you're not entitled to discovery.
Sure.
So the other side's got all kinds of evidence against you that you're not entitled to.
Okay.
And not even the judge gets to see it. And I think that's wrong. And I think it should be allowed.
Okay. Well, the court rules currently don't allow for discovery in civil cases in district court, or in civil infractions are treated the same way, speeding tickets, those things. Although certainly when we're involved in this case, we ask for the law enforcement report and ticket. The court currently has the ability to ask, to order discovery in civil cases. So if you're involved in a case with the district court where you would not normally get discovery, you can make a request, either through a motion or just make a request at a pre-trial meeting, and ask the judge to order civil discovery, and it will be granted. The reason is that traditionally the cutoff limit for cases in civil court and district was $10,000. It moved up to 25. So there wasn't the cost didn't justify the expense of discovery. Discovery can be expensive. But in those cases where it's appropriate, and the ones you've mentioned probably are, then you can make that request to the district court judge, and he can order it under the current code.
You can order it, but you doesn't have to order it.
Well, as judges, we don't have to do anything we don't want to.
Well, then as litigants, we don't have to do anything we don't want.
Right. So no, the court has the authority to order it. So let's make the request, and then under the court rule, it can be granted. And I think it sounds like those up here probably want to have open discovery and probably order this. Okay? I don't know.
Thank you.
Thank you. Well, Barb, I know that you don't have to do anything that you don't want to. But as Paul indicated, the discovery rules are governed by the Michigan court rules. Discovery is not mandatory in district court as it is in circuit court. Of course, if a party makes a motion or if the judge on his own motion orders discovery, that's when discovery is permissible. I'll tell you, I do a fair bit of civil infraction matters, and I've handled them in the past. My personal practice is that we just voluntarily exchange information because I don't want to go into court on the day of the formal hearing or hearing and have the opposing counsel stand up and just throw his hands up in the air and say, well, Your Honor, I don't have anything to defend, no reports, no documents. I need preparation time. I don't even know, other than what's on the ticket, what my client is being accused of. So in the interest of, and that's the thing, you know, when you're dealing with municipalities, you have to be good stewards of their fees because it's all taxpayer money that are paying the lawyer fees. So you want to be as efficient as you can and as cost effective as you can when you're representing municipalities. So rather than me billing and going to the court and then getting it adjourned and coming again and billing with my client more, I just exchange the information. The other thing is court rules. Judges have input into court rules, but the court rules are really approved by the Michigan Supreme Court. So, I mean, lawyers and other groups, they make suggestions, they make amendments to court rules, and as of now, I don't know if there's any movement out there, any steps to limit that as well.
Thank you. Okay, so we'll move on to our next question. Pretty good with one that's not Barb for a second.
Well, you don't have to be objective.
Even at this level, constitutionality must be considered. Is there anything that the Supreme Court has done that you disagree, that you don't agree? I feel like that is against Canon 7. Maybe not.
I think it depends on.
Would you guys like to answer that question?
I would like some more specificity if we can. The Supreme Court has done a lot of things. And which Supreme Court? U.S., Michigan?
I do not know, since you guys are...
It would be the United States Supreme Court. And,
okay.
And is there anything in particular, see, for me, what that would suggest, it would give you an opportunity just to stand apart. It doesn't necessarily mean that you're in any conflict with the court, but is there anything specifically on a national basis that you, for example, the ACA or Oberfeld v. Hodge, I mean, are either of these, perhaps if I specifically said those, are there any disagreements that you had? Because even in the Supreme Court, on both of those decisions, there was dissent. So it's not as if you're, going against the Supreme Court.
Mr. Cooney?
Start speaking the next way.
I think that.
Oh, good.
I
think we are going to go
Yes.
with, yeah, Mr. Jarboe.
Okay.
We'll go with
Okay. Thanks, Bob. He always punts with the hard ones. Well, look, it's an interesting question, but obviously, as we point out, the U.S. Supreme Court has ruled on hundreds of issues, and lots of them which are fairly divisive, to say the least. And so I don't know, as a judicial candidate, that it's probably, certainly my position would be, that it's appropriate for me to say I don't agree with what the Michigan Supreme Court did on this issue, or I agree with them on this issue. The reality is that, I think the question correctly points out, you get precedent from the Michigan Supreme Court, 9 votes, and it's 5-4, which is just, it's an amazing concept if you think about it, that you've got 9 of the best legal minds in the United States, and 4 of them disagree with what the other 5 did. So it just shows that people have difference of opinion. I think for the role that I hope to play as a district court judge at this level in Grand Traverse, Leland, Antrim County, having been practicing more than 35 years, is that we have to respect what the courts above us have done. And that includes Michigan Supreme Court, Michigan Court of Appeals, and quite honestly, even the Circuit Court has appellate review over what I would do as a district court judge. So that's the rule, that's the job. You have to follow precedent, and that precedent has to be respected. So that's the best answer I can give you the question.
Thank you, Mr. Jarboe. Mr. Kazim?
Well, I think I first of all, you know, as a district court judge, as you know, we won't be, any one of us, whoever is elected, won't be ruling or deciding on any of those weighty issues of constitutionality and like Jason's example, either the Affordable Care Act or the gay marriage decision. So setting that aside, I think so whatever opinion I give to you today, it is going to be more of my own personal opinion. And as a nonpartisan candidate, as a judicial candidate, I think it's probably not appropriate or for me to kind of confuse my judicial positions and my judicial philosophy with my personal opinions. The Supreme Court has spoken whether we like it or not. Both those decisions, I believe, were 5-4. And to the extent that if any of those issues ever had any bearing on any issues in district court, we are bound, as judges, we are bound to follow that law as it exists today. So I know that that's probably not the answer some of you are looking for, but unfortunately, that's the best answer I can give at this point. Thank you.
Well, I'm not going to comment about any specific case because I do believe it might violate the Canon 7 of the Judicial Code of Ethics, but at the same time, I agree with what my colleagues have said. We are not running to be legislators. We're not here to make laws. We are here to apply the laws as written. And as a judge, I believe it's our job to enforce the law as it is written. The rule of law as decided by the people, by their state legislature, that is the law that I would follow as a judge. And that's what we're sworn to do as judges, follow the mission of the United States Constitution.
Thank you. We're going to go on to our third question. For speeding tickets, is it better before a judge or magistrate? M-A-G-I-S-T-R.
Yes.
That is your
So this is free legal advice for it's my turn, right?
Yes.
Sorry. Sure. Just got up. So it depends on, you can go before a magistrate, and before the magistrate has certain limited powers, and the magistrate can, adjudicate on the ticket based upon a plea of responsibility. If you want, but the magistrate obviously does not have the full jurisdiction of a district court judge. If you want a formal hearing on your ticket, then you have to request a formal hearing, and that has to be before a judge, and then you are entitled to present your evidence and be represented by an attorney in those matters. So it depends on really what you want. If you want to just say, because when you're going to a magistrate, you're just paying the fine, okay, and you're done. If you want to contest the ticket, then you go to the district court and you contest that ticket and present your proofs, and the district court judge will make that decision. So there's no right or wrong answer here. It depends upon the individual who has been issued the ticket and what they want to do with it.
Thank you. Mr. Cooney?
Yeah, I believe the current procedure is a good one. The way it works is that there is an informal hearing in front of a magistrate who will decide the proofs. Generally, there are no attorneys that are involved at that level. If either litigant is dissatisfied with the result, then the case goes to a formal hearing in front of a judge. So you do have a right to a hearing in front of a judge, even though the cases start out in front of a magistrate. In fact, you can bypass the magistrate. In the court rules, it allows you to go directly to a formal hearing. And I think it's a good procedure because most of our violations are resolved by the magistrate. Magistrates are there because they are paid far less than the judges are paid. It's an efficient and cost-effective manner of resolving those cases. And most of the time, there isn't an appeal. Our office actually represents law enforcement if there is an appeal of those tickets in a formal hearing.
Thank you. Mr. Jarboe?
Thank you. I've had the experience of not only prosecuting and enforcing tickets as a prosecutor, but also defending those that come into my office with speeding tickets or other moving violations, just not that, just not speeding. So what I always tell people is that there's two options. One is to go to the magistrate on your own without a lawyer. Lawyers are not allowed before the magistrate. And you can have a full hearing before the magistrate. Talk about what happened, the magistrate will ask you questions. Typically, law enforcement officers involved, they have to be present, and they explain why they issued the ticket. If you win at the magistrate level, then the case is over and you're done. But if you lose, you have a right to file an appeal. And that appeal then would be heard before a judge, and it's called a formal hearing. And lawyers are allowed to be involved in formal hearings. So the question, what's the better place to start? I always recommend to people they start in an informal basis. They don't have to pay the lawyer's fees. If they're not satisfied with the result, they lose, and they want to contest it, then they can come back, hire an attorney, and go to see the district court judge with the attorney on a formal hearing. This is an example of one of the things, as exciting as it sounds, that district court judges get to do. Listen to speeding tickets. But it's important because they have an impact on people's driving records and other things that get processed through the district court. So, but again, magistrates are there to handle most of the tickets. If there's appeals from those, or people want to go directly to the district court judge, that's there.
Thank you, Mr. Jarboe. Okay, we're going to go to one of our other questions here. Hey, I think Mr. Kazim.
Yes, start.
Mr. Kazim.
Yes.
Okay, my apologies. The mission statement of the Sobriety Court is to enhance the public safety and community welfare by reducing recidivism among driving while intoxicated offenders. What is your plan, if elected judge, to fulfill the statements? Mr. Yes.
Well, I think our sobriety court is in good shape. And I say that because I attend the review hearings, the quarterly review hearings that court has. I sit on the steering team with the judge and the court administrator. And the court administrator at the last review hearing indicated that according to the state court administrator's office, we have one of the best sobriety courts in the state. If you're not aware of it, our sobriety court deals with drunk driving second and third offenders. And so we have a recidivism rate around 4 or 5%, whereas the statewide average for people who do not go through and graduate that program, it's in the 40% pocket. So we're keeping the roads safer, we're saving taxpayers money in the long run, and we're also fixing some people's lives because it's an 18-month to 2-year probationary period. And if you can get somebody off alcohol for that long a period of time, you really accomplish something. And of course, everybody has, it's not just that individual, they have an employer, they have kids, they have moms and dads, they have other family members who are all affected back in 2016. And we have people who have been off opioid drugs now with that drug treatment for coming up on 2 years now. That's kind of amazing because the recidivism rate for opioid dependent people is about 72 hours, believe it or not, after they get out of jail for 6 months or 90 days or whatever the sentence is. So again, we're making a big difference if we've got people that have been off drugs for that long a period of time. I sit on the Michigan Association of Treatment Court Professionals.
Okay, Mr. Jarboe.
Thank you. We have two treatment courts, the sobriety court, which Bob had alluded to, which is currently run and operated by Judge Michael Stepka, and then the drug court program, which is run by T.J. Phillips, Judge who's retired. I've had clients that I've asked to and have been successfully placed in both of these programs. I've been intimately involved in there in watching them, watching people, your neighbors, who have addiction problems, whether it be alcohol or opioids, take advantage of these programs. I can tell a very brief story of a man who lived out on the peninsula who was arrested and charged with a felony drunk driving. And 2 days later, as he was driving home from the court hearing, got arrested and charged with another felony drunk driving. His wife was getting ready to beat him. He talked to me about committing suicide when he was in my office. With the assistance of Judge Stepka and the sobriety court team, he was evaluated and placed in the sobriety court program. And this is after having spent 30 days and 60 days in 2 inpatient programs on state. He's successful in that program. I see him when I go to court in the district court coming out of sobriety court meetings. And it is a great example of what a treatment court with the correct personality in the judge, in the probation officers, in the prosecutor's office can make happen, as opposed to simply straight punishment. We need to understand that there is a role for straight punishment and a role for jail. But the sobriety court program, in my experience, has been very successful. The drug court program is fairly new, 2 years old. I'm happy with the results I've seen from my clients, but I also know that that's a different evil. The opioids are a much different and stronger evil in our society than the alcohol is death, and we have a lot of work to do in that.
Thank you. Mr. Kazim?
Well, the sobriety court, that's been in place since, I believe, 2001. So it has a very excellent track record in terms of its viability and its effectiveness in achieving the goals for which it was set up. It's nationally recognized. And the great thing about the sobriety court is that it involves the necessary stakeholders. It involves the law enforcement, the prosecutor's office, the judges, the defense bar, and obviously the providers in the community that work together as a team in helping individuals that are afflicted with alcohol abuse disorders and addiction issues in controlling them, in treating them, and subsequently in reducing the overall alcohol-related offenses in the area. And the nice thing about that is that it's in all 3 counties. It's in Antrim, Illinois, and Grand Traverse counties. So, it's a very well thought out program. You have to meet certain eligibility criteria. You have to go through a process. As an individual who is the offender who is eligible or who is interested in participating, they have to make a significant emotional, familial, and commitment to you have to be committed to get well. And I think that this program achieves that because it's not just a mechanism to avoid getting a longer sentence. It's actually a mechanism to identify and target those individuals who are serious about addressing their issues and confronting their issues and getting treatment. And as elected, I believe, obviously, I am going to continue making sure that the program continues to be operate as effectively as it has been over the last 17 to 18 years. Thank you.
Thank you. Okay, we're gonna go on to our next question. If a police officer files an
Affidavit.
affidavit that he personally served a defendant, but he didn't, what happens next? I don't know if we want to go into, these are more straightforward actual questions. I love these questions, but
If a cop serves the court with an affidavit that says he served the plaintiff or the defendant, but the defendant can prove otherwise, what would your job as a judge be?
Would you
Uh,
back at that?
Mr. Cooney?
I think was it you? Oh, you did all that.
My apologies.
Yeah. Oh, that's fine. Well, if an officer signed an affidavit, which is under oath, saying that he did something like serve papers, and he didn't do it, then obviously the officer is lying and subject to being prosecuted for lying, for potential perjury. Yeah, that's what the court says.
Correct answer. What happens to the case?
Well, the case doesn't necessarily stop. The service would be invalid. Okay, and the documents could be reserved, assuming the summons hasn't expired. As you know, the summons has a certain lifespan. And so as long as that lifespan hasn't expired, then the summons could be reserved. Or the plaintiff could ask for an extension of the summons too, under the civil law. So there's ways to keep the case moving. But obviously what you described is a much more serious concern for any of us sitting as a judge, because the last thing in the world is you don't want people coming into court to start playing home. And that's what you described.
Mr.
So, in terms of procedure, there are a couple of things. Obviously, if it's a civil case, if you have not been served, which means that you, I'm assuming you are the defendant in this case, because plaintiffs usually serve their complaint on. Let's talk about the complaint, okay? Someone sues you, and you have to be served the process, and you were not served, and yet in your hypothetical, the officer submitted a proof of service back to the court saying, I served a copy of this complaint. So there are certain consequences resulting from that, which is number one, that you don't file a timely answer, so you're at risk of getting a default judgment entered against you. So, as a judge, if it's proven that you were not served, then one of the things would be to set aside the default judgment and require the plaintiff to serve you with a copy of the complaint and allow you the necessary time under the court rules to provide you with an answer so that you can file your answer to the complaint. The other scenario would also be that summons is usually valid for 90 days. If it's past that 90 days, have a new summons issued and then have that served. Either way, as a judge, if it's proven that you were not served with a copy of the complaint and it's not through your fault that you didn't file an answer or response, then as a judge, if to be fair, you give the party the opportunity to correct that omission and the defendant to file a response. As to the officer, obviously, if it's an affidavit, it's sworn under oath, that's a violation of that sworn affidavit, and that's a grounds for perjury. So.
Thank you. Okay.
I believe Mr. Kazim just described the proper procedure and what the court should do in that case. What I can tell you is there's nothing that undermines our court system and our system of justice more than perjury. And so as a prosecutor, I've been very aggressive in my approach to perjury cases. I know that our circuit judges feel the same way. In fact, they've stated that perjurers go to prison. Forget about jail, we're going to send them to prison, and that's happened in many cases that I've prosecuted. The thing is, as a prosecutor, I have to decide, is this an intentional act? Did the officer actually lie about serving the affidavit? Was there some mistake made? Those are the types of decisions that prosecutors have to make every day. And of course, perjury charge, which is a felony offense, probably going to subject that person to not just potential but actual prison time. You have to be very careful in making those decisions. And so prosecutors have been called by the Supreme Court ministers of justice, in that they have to make those tough decisions, much as a judge does. Our decisions are not just rack up as many convictions as we can. Our job is to do justice. And so I believe my colleagues have properly stated the correct procedure in this case. I just wanted to address that point about it.
Thank you. Okay.
Okay, what question would you have for the other judicial candidates and their answers?
Wow, okay. Assuming it's my turn?
Yes.
Okay, great. I really hadn't thought about that. I've been so focused on answering the questions. So the question is, what question I would have for these two gentlemen?
Yes.
Yes.
Wow, okay. I have only 3 minutes to...
2 minutes.
All right. I'm going to throw a softball at you guys.
Oh.
You know, tell me why you should be a district court judge than me.
And why? What question and why? And how would you answer it?
How would I answer it?
Yes.
Well, I think I will default back to my opening statement here in the initial 3 minutes. I mean, for all the reasons previously stated, when I gave my opening statement, I believe that I'm the best candidate for the job because of my experience and because of my representation of the communities throughout northern Michigan, including the 3 counties that is part of the district. So I won't bore these people with saying the same things.
Well, that was only 1 minute, so since it's kind of the same question as earlier, I'm gonna give you those 1 minute, if that's all right with you guys, for that. What kind of question?
Yes, your own question.
Yes.
And then you have to answer.
What question would you ask them, and how would you answer?
In your overall.
So I'm not going to respond to the...
You are welcome to if you'd like to,
You ask your
but
own
you ask what question you ask.
You know, the reason that I'm running for district court judge is after 25 years as a prosecutor, I really see this as the skill set that I have, the best way that I can help the community. And a big part of that, we've already talked about with the treatment courts. There's a reason why Judge Haider, who started our sobriety court back in 1999, has endorsed me by his quote about the appears on my flyers that some of you might have seen. And it's because he knows as a prosecutor, I jumped into those courts with both feet. I supported those courts. I have attended the review hearings. I sit on a board with Judge Haley, the Michigan Association of Treatment Court Professionals, which helps to set the best practices for how treatment courts should run. Because there are treatment courts in the state, believe it or not, that actually make the situation worse. They can be a problem, and we found that out with a lot of our juvenile drug courts. Okay, now you want to ask me a question?
That was the whole, that was the time.
All right.
Yeah. Okay. Mr. Jarboe.
Are you just going to ask how's your summer going?
Mine's kind of rough. Well, I guess I'll get to Haider's point. I don't doubt the integrity of either of these two gentlemen and what their intent is in terms of running, but I bring a different skill set. I'm not coming to this as a politician, as someone who's run for political office as a Republican or as a Democrat, I don't come to this as a government employee for most of my career. I come to this as a private lawyer who's practiced in the circuit courts and the district courts for over 35 years. I've handled every type of case that is handled in these courts and in the Court of Appeals and the Michigan Supreme Court. I've represented lawyers, judges in the home. I have a skill set, I believe, in terms of dealing with people in our community that I think fits serving as a trial court judge. And this is the position that's available now, and it's the right fit for somebody like me. My position.
Thank you, Mr. Jarboe.
Thank you. That 1 minute goes fast.
Okay. In the sobriety court, how do you see your role working together with the drug treatment court team to prevent repeat offenders? Yes.
Well, one thing that we found out from our this experiment is that we were putting drug offenders in with our sobriety court defendants, and that was not working. And so the court stopped doing that a few years back. And the reason is, if you're familiar with best practices in treatment courts, we don't put drug offenders in with alcohol offenders. It's a completely different group of people. It's a different issue with addiction. It's the same reason why our experiment with putting veterans in sobriety court didn't work either, or a domestic violence court. And I think we ought to have a specialty court for our veterans who have unique issues, sometimes tied to PTSD and all of the other issues that go on there. So, so what I would say in answer to that question is we have to follow best practices. There's a lot of science out there, a lot of studies that have been done that we on the board of the Michigan Association of Treatment for Professionals look at, that the Supreme Court Court Administrator's Office is looking at, and in terms of trying to find the best fit for people that are suffering with addiction issues. And so my simple answer is you don't mix alcohol and drugs. Bad idea. But that's the simple answer to the question. It doesn't work. It's not an effective way to run a treatment.
Thank you. Mr. Jarboe?
Well, and could you repeat the question?
Yeah, of course. In sobriety court, how do you see your role working together with the drug treatment court team to prevent repeat offenders?
Okay. And so really, those are two different things. The sobriety court, Bob's talked about it, and the drug court program. Those are two separate programs that are run by our current district court. I think the key, though, for our district court judge, as they currently do, is to provide leadership and guidance for both of those courts. And it's the judge that is going to have the ability to guide people through those programs and really set a tone of success in the sobriety court program and the drug treatment program. But they are different animals. The sobriety court program, which we talked about, that's been in existence for a number of years. And then the drug court program, which is still fairly new animal here in our community.
Thank you.
Yeah, I think if I'm understanding the question correctly, it's asking about what role the district court judge would play, or what we see as the role of the district court judge in the drug program or the sobriety court program. And the answer is that clearly the judge is for example, in drug courts, the judge conducts review hearings. Depending on which phase you are in, those review hearings are conducted once a month, and then twice a month, and then once a month, to determine, and it's the judge who everyone is reporting to, the different stakeholders are reporting to the judge about the progress of this individual, and the judge is determining whether this individual is progressing the way they should be progressing in accordance with the goals and objectives of the program, or whether they are not meeting the goals and objectives of the program, and whether something different should be done, or whether this is not the right fit. So right from the beginning, from the standpoint of determining whether a particular individual is the right fit for the program, that's the judge's fault. Of course, they consult with other people, but really it's the judge's decision to determine whether a certain individual, even if they meet the check marks on the criteria, whether they are the right fit from an emotional standpoint, from a commitment standpoint. And then as they progress through the different phases of the program over a 24 or 36 month period, whether they are, it's the judge who is making decisions as to whether they are appropriately and properly completing the program the way it should be completed. And so the judge is the pivotal, plays the pivotal role in the success of this program. Thank you.
Thank you. We are now going to go into closing arguments, or closing arguments. Your closing statements. It's actually going to start with Mr. Kazim. Oh yes, 3 minutes.
Thank you. Well, first of all, I really want to thank all of you for taking the time from your evening to come here and listen to all three of us. As I found out, during this campaign, judge races for a lot of folks out there are not as exciting as those political races, where you have your hot button issues and you're passionate about them and you're Republican, Democrat, or any other party leaning, whichever you have. Judge races, when I go door to door, a lot of times people just give me a little look as to, okay, good for you, good luck, and let's move on. Because they don't know. They don't, and when I started this campaign, I did some research and I found out that in Michigan, it's about a 30 to 31% of people even vote for judge races. And that was astonishing to me, because if you think about it, up here, once you become a judge, depending on how young you are in there for 20, 25 years until you turn 70, okay? And there are no term limits. You have term limits for all of the political offices. There are no term limits for judges. And judges play a vital role in your community, because they are the ones that settle your disputes. Whether they're criminal or civil disputes, they are the ones that are going to be making decisions on your behalf or your family's behalf when you have something come up in your life. So do you want the best candidate and the most qualified candidate in that position, and that is in your best interest? So I believe that I am the best candidate based upon my experience. My campaign is based on fairness and equality to everyone, regardless of who they are, based upon my experience. And if elected, I will faithfully perform my duties, and I will faithfully treat all the litigants that appear before me with dignity and respect, and regardless of what their status may be, and treat every matter the way it should be treated, which is of the utmost importance to the person, to that particular litigant, whether it is a big dollar case or whether it's as minuscule as a speeding ticket. So on August 7th, I ask for your vote. Thank you.
Thank you.
Well, I'd like to first of all thank your group for putting on this forum. It's interesting, this has been going on all year, and it's the first time the three of us have actually been asked to be together to speak to an audience, so we appreciate that opportunity. For one of us, it's going to be a short-lived session, because the primary is August 7th, and the top two vote getters that will go on to November, and you get to pick each other. I want to just talk again, just for a few minutes, that I have about why I'm running. I've been a lawyer for 35 years. I've been a prosecutor, I've been a defense lawyer, I've been a civil lawyer. I represented Huntington National Bank, I've represented Empire Bank, I've represented Cedar Creek, Shish Mountain. I've handled multi-million-dollar civil cases, and I've handled speeding cases. I've represented the homeless, I've represented people in the ministry, I've represented doctors, lawyers, and judges in personal matters. I'm a lawyer that people call a lawyer's lawyer, because they come to me with their problems that would be guided through the process. My goal is for the next district court judge to be a practicing lawyer who has a variety and wealth of experience, to handle the number of cases that come before the court. And that's what I believe I bring to this election. I ran 14 years ago. I was a finalist to be considered by the governor's office, Governor Snyder's office for the appointment for Judge Rogers. He retired a year and a half ago. And I believe that I'm a strong candidate for this position. It would be an honor to serve the community as your next district court judge. My wife and I have lived here for over 25 years. We raised our kids here. They're coming back. This is an important community to me, and I want to continue to be part of it. Thank
You. One of my colleagues talked about this is a real exciting race. It's hard to get passionate about the district court. I can tell you, I am passionate about this court and what I hope to do for the community. I just came from a meeting. I was late tonight because I was over at Michael's place, and we had two moms in the room that lost their kids to opioid addiction last year. Ann Griselle and Nancy Dow, who used to be my dental hygienist. These are people who are just like you and me. We never suspect that their kids would be addicted to heroin and street drugs. But I'm running because the treatment courts are important. And I know that, I don't know about my colleagues, but I know that those courts work because the judge has to take a special interest in people that come in front of him. The judge has to take extra time. It's not just 90 days and off you go. These people have to come back every couple of weeks. And the reason I think the treatment courts work is because the judge is taking a personal interest in those folks. It has to be. Because I don't know what the other factor is that's going on. And I know that I have the personal resolve to have the time, patience, the hard work, and the dedication to do that job right. As a prosecutor, I think I have a reputation of being tough on sex offenders, tough on people who commit armed robberies, murders, solicitation of murder, all the different cases that we've had, drug dealers. But when it comes to local people who have drug and addiction issues and alcohol, where people want common sense solutions to this. They want to see people fixing their lives. That's why I'm coming to this judge.
I want to thank you all for coming out tonight. And there will be a little bit of a question and answer period at the very end if you guys want to stick around and ask them some questions. Again, my name is Nicholas. I didn't introduce at the beginning. This is Marin. Thank you all for coming out. And remember to flip over your ballots and vote for them on August 7th. Yes. Thank you.